So my first tip is to involve HR or your legal advisors from the start. The reason I say this is because I've seen so many senior managers, directors over the years plan out how they want their restructure to look and then hand it over to HR to implement. The reason that's problematic is because evidence of predetermination can be fatal to the defence of a claim. A legal requirement in most cases is that there has to be a meaningful consultation. So my recommendation is to involve HR, discuss things at a high level at the start before you go down some routes or some avenues which might be difficult to back out of further down the line. Once you've had that early conversation with HR or your advisors, the next step I usually recommend is to collate all the relevant employee data into a table to give you an overview of what you're dealing with. The data you want to include will be job titles, pay, length of service, notice periods, that sort of thing. There are 4 reasons why this is a good idea. First of all, you need to identify who has more than 2 years service, 2 years continuous service, and therefore who has unfair dismissal protection. 2, you need to calculate whether or not you're dismissing more than 19 employees. If you are dismissing 20 or more, then collective consultations kick in, so you need to bear that in mind. Third, you need to identify who is on maternity leave, if indeed there is anyone on maternity leave. Mothers on maternity leave have enhanced rights in a redundancy situation, so you've got to take that into account. And finally, it's a good way of mapping out the potential cost of the redundancy in terms of notice pay, statutory redundancy pay, payment in lieu of holiday, and also potentially enhanced redundancy payments if you're planning to make them. Next up is the question of pooling. Let me give you an example. Say you have 5 account managers, but you've just lost a big client contract and you think you really only need 3 account managers as a result. It's not fair or appropriate to simply pick out the 2 you want to lose. What you're expected to do as part of a fair process is pool all 5 of them together, place them at risk of redundancy, and then use fair and objective criteria to score them against each other, and then you select the 2 who have scored the lowest, and subject to consulting with them over their scores, you would then go on to confirm their redundancy. Each case is different, and whether pooling is appropriate or not, and what pool is appropriate depends on the individual circumstances, but typically if roles are the same or interchangeable, then they should be pooled together in that way. Sometimes a manager will say to me, my employee is not performing, I want to make them redundant. The trouble with that statement is that performance issues, misconduct issues as well, they're specific, personal to the employee, and there's a very different way of handling those sorts of concerns. Redundancy, on the other hand, is driven by commercial reasons. In general terms, it's because a business is closing, or part of a business, or you just no longer have as much work as you did for the people that carry out that work. So it's important to remind yourself that roles are redundant, not people. Now, sometimes there is overlap between redundancy and performance. For example, if a particular team isn't meeting targets or performing, it might be open to the business to make the team redundant, to proceed without that function in the business anymore. But nevertheless, it's important to focus on the commercial reasons, not the individual. Navigating your way through the various legal obligations need not be difficult, but there is an option to shortcut the process, and that's by offering an enhanced redundancy package. Now, as part of that package, you would require your employee or employees to enter into a settlement agreement, under which they would waive their right to claim anything further from the business, and typically they would bring their employment to an end by agreement. As you can imagine, it comes at some additional cost, but many employers use it very effectively and find it can be very worthwhile because it gives you extra peace of mind and extra protection and security for the business.